thank you for joining us today for Foley & Lardner's web conference, Social Media and Influencer Issues in the Fashion, Apparel, and Beauty Industry. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session, allowing time available. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can access a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Taylor Bannister at tbannister@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. Please note certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form to Taylor Bannister at tbannister@foley.com immediately following the program. At this time, I would like to turn the presentation over to Laura Canosa, Chair of the Litigation Practice in Foley's Miami office, who will introduce today's speakers.
Thank you, Taylor. And good morning or good afternoon, everybody, depending on where you are today. As Taylor mentioned, I'm Laura Ganoza. I'm the chair of the litigation department of the Miami office of Foley & Lardner. I also lead the firm's fashion, apparel, and beauty practice, or as I like to call it, Foley Fab. I have a special passion for fashion in my personal life, and I've been lucky enough to be able to combine that through my litigation practice, representing designers and brands and fashion companies on a host of commercial matters, and also in my counseling and prosecution of copyrights and trademarks. And right alongside me is another trademark practitioner. We have my fellow speaker, Catherine, or as everybody calls her, Katie Khalifa. Katie is a star in Foley's trademark practice and advertising practice. She not only knows the rules of the trademark office like the back of her hand, she also has a lot of experience in dealing with legal issues related to social media, mobile apps, rights of publicity, rights of privacy. So she brings a wealth of knowledge on the topics that we're discussing today. So thanks, Katie, for being a speaker. And last but not least, we have Jessica Carden. Jessica is the Deputy General Counsel of Quality King Distributors and Perfumania Holdings. She supports various brands within her company, both online and brick and mortar. And she has extensive experience in the fashion and beauty industry, as before this job, she was a Senior Vice President and General Counsel for Vince Camuto, where she oversaw and managed all of the company's legal affairs. And if you follow Jessica on social media like I do, you know she is outspoken about social media and influencer issues, and I think you're all going to get a lot of value from her practical and real-world advice and the perspective that she's going to give as in-house counsel. So what are we going to talk about today? We're basically going to talk about 3 topics. We've kind of broken up this webinar into 3 areas, and we think that these topics will help you and also help you train your marketing team on how best to use influencers and how to create social media content that's not going to get your company in trouble. So the first topic we're going to talk about is selecting the right influencer. This could really, make or break the campaign that you're trying to use them for. Second is, once you have an influencer on board, we're going to give you some tips for what to include in influencer agreements. First, to make sure you have an agreement, because it's important to set forth the terms of the relationship regardless for how long or short it is. It's important to have things in writing for everyone's expectations. And then we're also going to talk about best practices with dealing with online content. There's a lot of content out there on the internet, and sometimes the marketing team is excited to be able to grab something and use it and promote it under the company's social media tags, and that may not always be the right thing. So we're going to give you some real-life cases kind of ripped from the headlines on do's and don'ts for using third-party content. So first is selecting the right influencer, and as I mentioned, this really makes all the difference. And depending on the person you select, that can make the difference between a really successful campaign and one that really just is a dud or results in a loss of money. So the first thing that you should think about in selecting the influencer is, ask yourself or have the marketing team ask these questions. What is the end goal? Are you just looking for, a social media sensation or star that has millions and millions of followers because all you want is large reach and eyeballs looking at your newest product? That's one type of influencer. Or are you looking for someone else? Are you looking for more of a micro influencer that maybe is someone that has less than millions of followers, but they have very engaged and devoted audience? So when they post something, that may lead to more conversions and sales, or at least get the consumer more engaged. Or are you even, maybe you're a smaller company yourself, you're a startup company. Would a nano influencer be really what your end goal is if you want to create someone that's more organic? So what's the end goal? And then does this person fit the brand? Sometimes with nano influencers, if maybe they're already using your product and that's how you find them because your marketing team is, looking for people that like the product. And so then maybe they're kind of a natural fit and organically they're right for your brand. Another thing though is regardless of who you find and you think they meet your goals, you have to do your research. And Katie's going to give some tips on what you do to investigate these influencers. And then at the end of the day, some influencers are going to be more expensive than others. Jessica will talk about some payment terms and things to include in the agreement about that. But before you even get there, you have to really think, well, what's the return on investment? This mega social media star is going to want a lot of money, and what am I getting in return? So these are the first questions that you should ask yourself before you select a mediator, an influencer. And so what if you don't? Well, if you don't do this, there are things that can go wrong. And there is a current case that's pending against kind of the fashion it boy, Luca Sabat, was recently sued by PR Consulting in state court of New York. And PR Consulting was hired by Snapchat to help them launch this new campaign for some eyewear that actually had a hidden camera in it. And they tapped Luca to be an influencer endorser of this new campaign, and he was supposed to post 4 unique posts. He was supposed to do 1 Instagram feed, 3 Instagram stories, and they wanted him to post this during New York Fashion Week and Milan or Paris Fashion Week. They also wanted him to be photographed wearing the sunglasses in public. And according to the complaint, he breached the agreement. He only posted one Instagram feed and one Instagram story. He never posted himself wearing the glasses in public and didn't do the other requirements under the agreement, but the company paid in advance. The total amount he was supposed to be paid was $60,000, but he was paid $45,000 in advance when he signed the contract, and he didn't comply. So they're in the middle of litigating that in state court. Nothing much has happened, but there's an example of something that could happen if you don't vet the people properly and make sure that you're going to get what you're paying for. So I'm going to hand it over to Jessica so she can talk to you guys about some real practical strategies on how you can avoid this. Jessica?
Hi, thank you. So basically, we've outlined 4 steps that you can try to follow and work with your marketing teams and clients to try to help them understand what their objective and end goal should be when they're working with an influencer. First of all, you'd want to look at what your actual partnership goals are. There's definitely been a lot of publicity and news articles more recently covering the fact that there are really different types of influencers and people who are going to do different things for your brand. If you're looking for just enhanced brand exposure, for instance, you're going to want somebody who might have a wide base, who's going to be appealing to your customer, the type of person you think is actually buying your consumer good. You want someone who's authentic. Thinking about that, I think there's a trend lately where you do have some influencers where it seems that their entire feed is paid content. I think that rings less authentic to their followers than what you might see where it's a nice blend of their own original content that isn't looking to promote some other brand, but is reflecting on their life, their values, and things that they're doing, which is why they even have people who find them appealing. Whether it's a beauty influencer who's actually doing the tutorials without necessarily, maybe they drop a few products in there, but it's not necessarily a paid ad. It's just them featuring favorite products, but also teaching the tips. Or a fashion influencer who might be profiling her closet or things that she does to put a look together, again, without it necessarily being something that's a paid ad. The loyalty, too. You want to also look within that, how engaged are the followers with that influencer? Is it someone where they repeatedly have, maybe if they have 100,000 followers, they repeatedly get thousands of likes on an individual post versus maybe a few hundred? And that'll tell you a little bit more about what the actual engagement or possible legitimate engagement with that influencer is and how loyal they are to the influencer. These types of things will also let you evaluate whether or not that's the type of influencer who can help build your own brand following and your own brand engagement, or if there's someone who, there are other influencers who are known for just being able to help you convert sales. So if they post about your product with a direct link to buy your product, there are influencers who have exceptional follow-through on that with legitimate return on that investment through sales conversion. So those are the things to kind of consider and evaluate. With the next type of thing, you want to look at the influencer's fit. How does that fit react with your brand? If you have a target audience for your brand who is millennials, you're going to want to look for an influencer who's in the same age group, who's consistent with what your consumer is looking at in their own life, what's authentic to them. You don't want, for instance, if you have a consumer for your brand that is maybe representative of a 35 to 55-year-old age group, a 21-year-old influencer is not likely to appeal to your target audience for your brand. You also want to make sure that the values align with your own brand values. There's got to be synergy between the brand for it to be authentic and effective for the use of the influencer. So, you know, if your brand is about promoting women and women's issues, you may not want to choose a male influencer who isn't also somehow promoting, supporting women in the same way. If you're seeking to promote diversity, picking influencers who look all the same image one after another is going to undercut what you're trying to achieve with that image. Now, I believe we've got Katie who's going to talk a little bit more about the next step, which is your investigation of the influencer.
Yeah, thank you. So obviously, one of the key considerations associated with choosing an influencer is evaluating their follower base. Does the influencer reach enough people to make the deal worthwhile? Are the followers genuine? There's a whole cottage industry associated with falsely inflating social media engagement numbers. Earlier this year, the New York Attorney General settled a probe into a group of companies that sold fake followers, likes, and views on social media platforms. For example, a customer could pay Devumi LLC $4,000 to get 500,000 new Twitter followers, or they could pay as little as $30 to get 250 likes on YouTube. The customers who purchased these fake views and likes included marketers, celebrities, business people, and politicians. The New York Attorney General asserted that selling the fake social media engagement deceives social media users by making the purchaser appear more popular or influential than she really was, and it also deceived the online platforms that prohibited such activity. Even though the settlement did not address whether the purchaser had engaged in illegal behavior, the FTC endorsement guides state that both sellers and purchasers of fake likes could face enforcement action. So it's important to do your diligence on influencers your company is seeking to work with. Any potential influencer should be open and transparent about her social media engagement statistics. If she's not, that's a major red flag. Brands should work only with influencers who have verifiable followers and engagement levels. And here are some other red flags to look out for. A sudden and inconsistent increase in followers. That could be indicative of paying to add a bunch of followers. Mainly followers from outside the influencer's home country. Or suspicious following activities like quick follows and then unfollows of other people's accounts. A limited number of posts in relation to followers. For example, if the influencer has 500,000 followers but only 30 posts, that doesn't show genuine organic growth. Little to no social media engagement is something else to look out for. If there are hardly any comments on any posts, that's a sign that the followers are not really engaged with the person. Or consistently off-topic comments or limited comments, things that just say great or have a heart emoji, could be signs that they're bots or paid followers, not genuine social media users who are really engaged with the influencer. So as you can tell, there's a lot of research to be done before signing with an influencer. And Jessica is going to talk a little bit about whether this investment of corporate resources is really worthwhile.
Yeah, and from the in-house perspective, thanks, Katie, that I just want to acknowledge that I have heard more of my in-house clients start to ask from the higher up and put pressure on the marketing teams about the question of ROI. Basically, how do you even gauge if there is a return on the investment in this influencer? If you continue to do print advertising in traditional media, whether a magazine, you at least have subscription numbers to know that if that goes out to the subscribers, you have that many potential impressions. Even if they have a certain number of advertisers or sort of followers for the influencer that you can promote internally, there's no guarantee that many people are going to see your post. Sometimes it's all about the time of day when a post is put up, the time of week. So it is hard to gauge these things. And just a few things you can consider is basically looking at what types of things, if that is a niche marketer who might be a niche influencer who might be able to give you a limited but highly influential exposure to your targeted consumer versus someone who can do sales movement, there are a few metrics you can look at. You can always look at if they are doing sales conversion, what did that influencer do for you with respect to sales conversion after the post goes on? If you paid too much against what you got for sales conversion, maybe that wasn't worth it. If you want to reuse that influencer because there was a sales bump, you might want to try to negotiate a reduced fee or a different type of fee structure against what types of posts that they're going to do. The other thing you can look at as well is what kind of follower bump your own brand got after different influencer posts. So if you can space your posts enough where you can see if there was actual follower growth
after one of your influencers posts, then you can maybe track that as another measurement as well. You can also track your impressions, your clicks, the shares, the likes, and story views as well. And you do want to start tracking those because some of these influencers all have such different fee structures that you may find that using a lower cost niche influencer is actually more beneficial for your brand than using someone who commands a high price for a perceived high volume of followers. And I'm going to kick this back to Laura, who's going to talk further about tips for influencer agreements.
Thanks, Jessica. So now everybody knows how to pick the right influencer, make sure that they fit your brand, make sure that they are going to give you the right return on investment. But now comes the important part of detailing what the real agreement's going to be with the influencer. And we're going to go over some of the most important terms that you should consider and review in your current agreements. Or if you don't have agreements, make sure that they are included in the influencer agreement in order to get the most out of your relationship, and beyond that, really to just have expectations on both sides about what's expected from the arrangement. So the first thing is what to expect, right? So it should really be detailed exactly what the influencer needs to post. Like we mentioned in the Luca case, I think one of the reasons that the PR firm was able to bring an action in the first place was that the agreement had specifics about when things needed to be posted and what things needed to be posted. So spell out exactly what you want from the influencer, how many posts, what kind. Is it going to be an Insta story? Is it an actual post on Instagram? Do you want a YouTube video? Is it something kind of more transient like a Snapchat story? A combination. Just make sure whatever it is, you come to an agreement about it and you set it out in the agreement. Sometimes the best way to do it so you don't have to change all your agreements is to have your template, your form agreement that you use for all influencers, but set forth these specific things in a schedule of what the expectations are. You could add that as Schedule A to the agreement, and it will tell them exactly what they need to post. Another thing is when. So you have what they need to post, but it's also important to have a schedule. You should have an outline that explains what the nature of the campaign is, how long it's going to be, what the influencer is required to do and when, set deadlines, especially if you have an approval right as a brand or advertiser, you have the approval right to review any of their posts. It's important to give them a deadline as to when they need to provide you the content so you can give your comments. Also, when you want them to share and actually post the material, for example, during Fashion Week or on a particular day to coincide with a launch of your products or another particular day that you have in mind, it should be clearly indicated in the agreement. If it's a longer campaign or one where the influencer is required to post more than one time, you should set out the time between posts so that they know exactly how long between maybe one Instagram post versus a YouTube video needs to be. But again, set it out in the time. And nowadays with our global, everything being so global, the influencer may not be in your time zone. So just either make sure that everyone's on the same page as to what time it is that these things are going to be posted. And again, just by having it on a separate schedule with all the information, it makes it much easier to make sure everyone's on the same page. Beyond that, it's also important, again, depending on the nature and length of your relationship with this influencer, it's important to look at the terms about who's going to own the content and what other content can be used by the influencer. So the contract should really specify who's going to own the content that goes up there. If an influencer is taking their own selfie, for example, they're typically going to be the ones that own that photo. So there needs to be arrangements made in the agreement, if the brand or advertiser wants to be the owner of all that content, there needs to be something in the agreement that gives the brand ownership rights, or at a minimum a license to use it. Because if the brand really likes the post and wants to reshare it or reuse it later in another campaign later on the road, you need to make sure that the brand has the right to do so. So that's very important to include that in the agreement. Also, to the extent that you don't want this influencer to be doing the same kinds of posts for competing products, that's something that's important to include in the agreement. And, be as specific as you can be. Nowadays we have a lot of lifestyle brands that are overlapping, so, it may not come to mind that, what you think is a competitor, and if the influencer may not think it's a competitor. So specify, what you believe is a competitor, and make sure the influencer knows that they are not to post anything with the competing products, so that it doesn't dilute the effect of the campaign that you're trying to have. Another really important topic is payment, and Jessica is going to talk a little bit about that.
Thanks. I do want to add to the prior, as far as the deliverables, those of us who are in-house and those who have really good relationships with your in-house team may be aware that part of it is a timing issue. So if your in-house team wants advance notice about when content's going live for an influencer, often they need a day to react on their own, or at least to prepare to react, so that they have someone on the administrative side of their own social media accounts who can push that content out, again, to your own brand account. So that's part of the timing reason, and it's important to understand how your internal clients' operations work on that end to make sure that you give them the time and the contract they need to make sure that they're getting the full benefit of the paid campaign. As far as paying for the campaign, though, there are a lot of different ways to devise the payment structure. The optimal way for the brand owner is obviously to pay for everything after the post has gone live, that you're not prepaying for a post. And if you have, 8 different parts of a campaign, maybe 2 Insta stories, 4 Instagram posts, a couple tie-ins to Facebook or Snapchat, you're going to want to try to set out a payment structure that ties to when each of those goes live, or at least maybe group them so that you're getting something staggered over every few weeks or every few months if it's a longer brand ambassador type campaign. Typically, I have seen influencers who want at least some sort of down payment in advance of the time that they're going to put into committing and preparing the content. So don't be surprised by that. I think for us, a lot of the fees internally that we run are not so expensive that we can risk prepaying maybe half the fee, but we delay the other half of the fee typically until after all content that we've agreed to has gone live. So I think that one tends to be the arrangement that maybe influencers are most comfortable with, as well as brands. But if it's so critical to the effectiveness of the campaign, you really need to try to stagger the payment fee, or maybe perhaps agree to put payment in escrow if that's helpful. As far as FTC compliance for paid content, just to note that this is also going to be something that is much like any past historical endorser. And as a brand, you really need to have the responsibility to train both your internal team about how we should be using how we should be using influencers consistent with the FTC guidelines and the law. But also, you need to convey your expectations effectively in the agreement to the influencer. And I believe that we're going to be talking a little bit more of that with Katie.
Yeah. So we're going to talk about some of the nitty-gritty with FTC compliance. So let's see. Let me go this side. So when does an influencer need to disclose that she has a relationship with your company? If the information would impact the weight or credibility that a user would give to the influencer's review, it should be disclosed. That means any incentive should be disclosed. Obviously, the payment of any money would qualify as an incentive, but also less obvious things. Things like free products or services, sweepstakes entries, chances to appear in a commercial or an ad, charitable donations, or free trips all merit disclosures. And where do you put the disclosures? The rule is that they should be clear and conspicuous. They should be hard for a viewer to miss. For example, on YouTube, it should be in the video itself and in the text description. On Instagram, it should be superimposed on the photo or video or in the first 3 lines of text. Twitter, it should be one of the first hashtags. And Snapchat, it should be superimposed on the photo or video. The disclosure should be easy to notice and read in the time followers have to look at the image. The viewer should not have to click more to see the disclosure. And part of being clear and conspicuous means that the language should be obvious and it should be unambiguous. For example, instead of using hashtag SPON, use hashtag sponsored. Words like ad, promotion, or paid ad are also unambiguous. The fact that a platform may have character limits is not an excuse for failing to make adequate disclosures. And now we're going to go over 2 FTC enforcement actions based on inadequate disclosures. The first one involves Lord & Taylor. Lord & Taylor engaged in a product bomb marketing campaign. They paid 50 influencers to post photographs of themselves wearing this asymmetrical paisley dress on social media, tagging the Lord & Taylor corporate account. Lord & Taylor pre-approved and edited each of the Instagram posts before they went live, but the company failed to add any disclosures that they had paid the influencer, or that they had given her the dress for free, or that the post was part of a Lord & Taylor marketing campaign. The advertising campaign was wildly successful. The company reached over 11 million Instagram users in just 2 days, and the dress sold out. But the FTC charged Lord & Taylor with deceptive advertising. Lord & Taylor settled and agreed not to engage in misleading advertisements in the future and to keep copious records for FTC review for the next 5 years. In 2017, the FTC charged 2 gaming influencers, Trevor Martin and Thomas Cassell, with deceptive and misleading advertising. Martin and Cassell posted tweets like the one you see here, boasting about how much money they made on a game called the CSGO Lotto. They failed to disclose, however, that they were co-owners of the game. And certainly a social media user would take this kind of tweet with a grain of salt if they knew that it was the co-owner saying he made $13,000 in 5 minutes, as opposed to a totally unbiased independent user. Martin and Cassell also paid other gamers to post positive reviews about the game. They also settled with the FTC and agreed not to misrepresent that endorsers were ordinary users, to use clear and conspicuous disclosures, and to maintain strict records and submit them to the FTC for review for 5 years. So the takeaways here are to disclose all material connections, where material means anything that could potentially influence how a customer views the veracity of the product review. Make all disclosures clear and conspicuous, no obvious, prominent, unambiguous. Space constraints are no excuse for inadequate disclosures. If there's not enough space to make the required disclosures, then that's not the appropriate platform to run the promotion. And finally, treat each post as a standalone advertisement. You don't know what order or context people are going to encounter each post, so each post has to have all the necessary disclosures. Now I'm going to hand it over to Laura to talk about requiring approval rights for social media posts.
Thanks, Katie. Well, before we get that, I saw that somebody did ask a question about, you really need to do hashtag ad at the beginning of a post. Nobody really does it. And, the answer to that is, it has to be clear and conspicuous. So if it's not going to be somewhere right at the front where you can read it, it's got to be in a place where someone is going to be able to see it and it's separated from other content. So if it is on Twitter right at the end, it may, and it just goes as part of the the entire ad and you can't see it, then that's really not going to comply. So at the end of the day, you have to kind of look at it objectively to see if someone's reading this, are they going to be able to tell that it's an ad? And I think if you're able to look at it objectively and reasonably and see that it is sponsored, then you'll be fine. So hopefully that answered the question. In terms of approval rates, we kind of touched on this before in terms of the schedule, but it's really important for the brand to have the ability to look at, approve, and change, frankly, if they're saying something that's not accurate about the product, to look at the content and make sure that they have the right to do that. That's why having a schedule up front is so important, to make sure it gives the brand enough time to do that. And as Jessica said, from an in-house perspective, to the extent that the any in-house counsel or there's a legal review staff looking at these posts, you just want to make sure that they have enough time to do it so that you get the right feedback and the content that ultimately goes up, it's something that is what you want from this influencer. We also talked about ownership a little bit, and just a reminder that this should be a consideration. Make sure you think about it, and if it's something that the brand wants to own, make sure you make specific provisions for that in the agreement itself. And also, if you're going to own it versus a license, a lot of this is going to depend on the influencer who has the most leverage when it comes down to it. I mean, if it's a super high-profile influencer, they may decide they want to keep all the rights, and that's how they do it, and the best you're going to get is a license. Make sure it's broad enough that it encompasses all of the use that you intend to use with the content, and include something like media that's known and become known in the future, because who knows what the next platform will be. But make sure you make provisions for that. Another really important clause to include in agreement is a moral clause. I mean, we've seen what could happen when a really well-known influencer celebrity does something really stupid or something that just gets them into hot water, and the brand no longer wants to be connected to them. So make sure you have something in agreement that addresses that. We've given an example of some sample language that you can use to give you that right to be able to terminate an influencer, or a number of other remedies. But make sure it provides for something like this in your agreement. You should also have a specific requirement that they can't discriminate against any protected class. You don't want to be associated with someone that's doing that anyway, so you want to make sure you give yourself a right to get out if they do. And this next slide, we mentioned some of the remedies that you could include in the agreement to make sure that you have the rights that you need to address any issues that come up if the influencer does something you completely did not expect. You can terminate the agreement. You can have the right to suspend them for an amount of time. There could be a monetary penalty. You could ask them for damages back. But in any case, whatever it should be, you should make sure to give yourself the right to do that in the agreement. And more importantly is that before that, you should have a plan in place to monitor the influencers. You want to know what they're doing with your content, with your brand, when they're associating with you. So the brand should have a plan in place to monitor what they're doing. It doesn't make any sense to give them money for posts if you're not monitoring what happens with that. So make sure that your marketing team or whoever is in charge of following up, everything doesn't end once you have the agreement signed. That's just part of it. Then you have to monitor to see what the influencer does. And Jessica is going to talk a little bit about that and how that happens kind of in the real world in the company.
Thanks, Laura. So part of it is obviously you need to decide if it's right for your company to have a social media policy. A lot of handbooks for a lot of companies will have a handbook that will address social media use by employees as it relates to posting about other employees. I feel like that's pretty much tied in with whether or not, how you're going to treat the treatment of fellow employees to be non-discriminatory in that effect. But you also have to decide to what extent are you going to restrict them from talking about the brand. And the reason I suggest that is that there is content in the FTC guidelines that do address, particularly the FAQ sections, that if there is a post by an employee of a brand, it can actually be perceived as being an endorsement or even a paid endorsement because that person receives salary if it's not disclosed as being done by an employee. So it does behoove the company to either have a policy that addresses posting by employees or has guidelines for what would be permissible posting by employees and how they should do their own disclosures. You're going to want to also implement some type of training and to address and instruct your employees with respect to whatever policy you put in place. If you use an outside PR firm, that does not relieve your company of responsibility. In my experience, addressing these issues from an in-house perspective, use of a PR firm has actually increased my need to monitor our social media accounts. They do not have the same standard of risk that I would impose on our own company for controlling and posting our own content. They have different views as to what they feel is permissible under the law, and usually, I'm just going to be blunt, it is a much broader viewpoint of what they think is permissible than I would advise my own clients. So you really have to be extra involved if your company is using a PR firm to manage your social media content. You need to look at within your own influencer agreements. If they've breached, if they've haven't complied with deadlines, get ahead of it. Get ahead of it before it gets too late. And certainly address whether or not they can talk about new products or other things before you're prepared to launch a product. All of this can and should be in your contract. One of the things that I would definitely advise to address in your contract, particularly in your the terms that would deal with warranties and representations, is to realize that some of these influencers have gotten so big and they really are promoting their own brand now that they no longer do their own photography. So under copyright law, you have to think about whether or not they've engaged a photographer or production team to produce the content that you're going to benefit from. And if they have, how have you ensured that the rights that those people may have into the content, particularly the photographer, have been secured and have been transferred if you're going to own or use that content. So that's something you really need to push to them. If they're the ones creating the content, you need to make sure that they somehow are doing what they need to legally to acquire all rights to that content before they either pass ownership to you or pass the license to use to you. And that needs to be in your warranties and your representations. Certainly you want them to comply with all applicable laws, FTC guidelines. You need to think about what type of content. Is it appropriate? Is it likely to be libelous or somehow inappropriate based on moral standards? You want to make sure it doesn't disparage the company and the brand as well. Or maybe if you're an apolitical brand, you want to make sure it's not going to address any political issues. It has to tie into your company's own brand standards. And one way that we've done that in the past here is if we're trying to set a standard for what content and the imagery of the content that we think is appropriate, we usually say that certain posts that the influencer has done maybe in the past month, or you could even point to an example, would be the type of standard that we would visually accept, and anything that matches that standard would be acceptable to us. I want to point out as well that in a contract, do not hesitate to request from the influencer a revision opportunity. Your marketing people will very much love and appreciate you for this. If they can, like any paid content producer, see the first pass of whatever they want to do as the draft post, and then get a right to maybe have a revision built into that. So, maybe the color seems off, or maybe they want a slightly different view of the influencer or different placement of the product in there. You can certainly ask for that. I've been successful in getting a revision right, in addition to an approval right in most of our influencer agreements. The bigger ones probably are not as fond of that, but it's worth an ask. And as far as indemnification, always get that the FTC disclosures is something that the influencer is going to be liable for. They're the ones who are posting and originating the content. They have to disclose it up front. Otherwise, the FTC is going to look probably more to the brand because of the deeper pocket, the easier ability to negotiate a settlement with them and hold them to it than to the influencer. And to that point, I want to just say that, companies, obviously there were 90 or so, and we'll talk about it shortly, influencers who got letters. You can still work with any of those influencers who have been under the FTC's watch. Just be extra cautious with how you hold them to the disclosure standards if that's what the FTC has flagged to them that they're not doing properly. So it's not that you should avoid those influencers. It's just that you want to do more in your contract to the extent you can. And then with respect to termination rights, you do want to have a clear term length in the agreement. I usually add whatever the final payment terms would be, if we're paying 30 days after the program completes on that 30 terms, or if we're going to pay maybe within 5 days after the last post. That is going to be at least the end of my term length to cover for that period, maybe with a little bit tacked on for comfort. And the start date is going to be before it actually posts. It's going to be from whenever you sign that agreement and start working with the influencer, providing product to the influencer, providing instructions and guidelines for what you want the scope of the campaign to be. You're going to have termination rights as well in there, failure for them to meet any of the deliverable timelines, failure to give you the advance notice and approval right if they're supposed to do that in the contract, any other breach, any reputational damage that they might have, failure to do their disclosures. If they're supposed to do a live story for you, that has to be around the timing that you implemented, so that should be impacted there as well. And I think I'm going to turn it over to Taylor right now, who's probably going to be providing the CLE code, I believe.
Yes, thank you, Jessica. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question on the screen after it is announced and press the Submit button. The code is 641NM. That is 641, N as in Nancy, M as in Michael. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. And again, the code, one more time, is 641, N as in Nancy, M as in Michael. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form, enter the code, and return it immediately following the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. At this time, the poll is now closed. I would like to return the program back to our speakers. Thank you.
Thanks, Taylor. This is Katie, and we're going to start talking about how to interact with third-party content, what sorts of things you need to keep in mind to avoid liability. So the creator of a post owns the copyright to that post. Tagging a brand should not be construed as permission for that company to reshare the post as part of their own advertising or marketing. And I think Jessica is going to talk more about that a little bit later. if you want to use a third-party post for commercial purposes, it's best practice to obtain the poster's consent. And you can do that just through a direct message or something as simple as a comment on the original post. And we're going to go over a case that talks about what happens when a company did not ask permission before using something they found online. In Brammer versus Violent Hughes Productions, a professional photographer, Russell Brammer, uploaded a copy of this photograph of a Washington, D.C. neighborhood to the photo sharing platform Flickr. A film production company found the photo and used it on their website. The website advertised a film festival that they were hosting in the D.C. area, and they used this to identify the same neighborhood that Brammer had taken a photograph of as a nearby attraction for the festival. Brammer sued the film production company. The film production company argued that their use of the photo was fair use, and they actually won on summary judgment at the district court. But then in March of this year, the Fourth Circuit reversed the district court's decision, and the Fourth Circuit held that Violent Hughes' use of a cropped version of Brammer's photograph to advertise local attractions was 1, a commercial use, 2, non-transformative, and 3, did not serve the interests of copyright law. So, as a matter of law, Violent Hughes' use was not protected by the fair use defense. The case has been remanded to the district court to take action consistent with the opinion. The takeaway here is ask permission before using any photograph or other content you find online. Now I'm going to turn it over to Laura to talk about a fun and recent case involving Miss Kim Kardashian.
Thanks, Katie. So, this is an interesting case that Kim Kardashian filed against the fashion brand, online brand, Missguided. So you see there, Kim Kardashian is wearing an outfit that was designed by her husband, and she kind of taunts the fast fashion brands and says, at least let me wear this before you knock it off, because that's what they do. They knock off what she wears. And she, exactly as she kind of thought, of course, Missguided writes, I think it was the next day, that the devil works hard, but Missguided works harder. And there's only a few days before this drops, and of course they tag Kim Kardashian. Well, she sued Missguided, and this is not the first time that they've referred to her. In fact, they used her picture, her family's pictures, in order to advertise their clothing and basically kind of mimic whatever she's wearing and make links so that they can sell their competing knockoffs. So she filed a complaint in California, and what first that I love about this case is that her loan-out company is called Kim's the Princess, Inc. I think that's wonderful. But what's really interesting is that, she sued them for right of publicity, trademark infringement, and misappropriation and false designation. In the complaint, she actually references an article that was posted by The Fashion Law, which is a fashion blog. And that blog article kind of seemed to insinuate that Kim was it was kind of a marketing ploy, and that she was in cahoots with this Missguided brand, and that she was working collaboratively with them in secret, and this was just a marketing ploy. So she used that as an indication of, people are believing that I am endorsing this brand, even look at these articles that have been written about it. So just a couple of weeks ago, she got a judgment. Now, it's a default judgment because Missguided didn't appear, even though they were served with the complaint. But she got a judgment for $2.7 million in damages and attorney's fees. The court ruled that she would probably get an average of $300,000 a post if they had legitimately reached out to her and asked her to do this. And there were 9 posts that were the most egregious in that they were really actually hawking her image to sell something. So they came up with a $2.7 million figure. But, here's an example of, a celebrity actually taking action for misusing her name. and her likeness in order to sell. So it's really an important lesson to make sure that you get the licensing rights. And Jessica's going to talk about another one of her favorite cases that I know she uses to train people, and a couple of other cases she's following in this area. So go ahead, Jessica.
Thank you. So, yeah, of course, anybody who's been working in the social media space has been aware of the Katherine Heigl, Dwayne Reed case for the last 5 years. And it's one that I think on first glance, obviously people can understand what Dwayne Reed's excitement and interest was to have a celebrity like Katherine Heigl at the time walk in and be shopping there and be seen walking out of the Dwayne Reed. But it triggered a lot of concerns on her end, basically about the misuse and misappropriation of her image and for the promotion of their own brand, so for commercial purposes. It was a paparazzi shot that was used by Dwayne Reed. So that's an instance where even if they got the photography license to use it through, any type of, Getty Images or something like that, you still have to take into account the rights of publicity of the person who's featured in the image, and in some of the states, the rights of privacy as well. She ended up filing suit in the Southern District of New York and was seeking $6 million plus in damages. They ended up doing a settlement where Dwayne Reed did a contribution to benefit, I think, a foundation in benefit of her brother, and then she dismissed the lawsuit. The reason I bring that up, though, is that there are circumstances out there, real life. It's happened here in my practice, dealing with internal clients, where there's a presumption that if a celebrity or someone tangentially affiliated with a celebrity has posted content with a tag back to your brand, whether it be in the hashtag or it be an account tag back, that it's safe for you to repost. I'm just going to reinforce that, of course, the best practice, as Katie pointed out earlier, is to try to use efforts, whether through direct messaging or comments on posts, to get some sort of permission to repost. In my experience, though, you're not going to necessarily be able to have that get you the answer you're looking for. You may get no response from the person. So what can you do to assess risk when people are going to give you the common response internally of, well, everybody does this? So what I've used kind of as a baseline is if the celebrity or the endorser or the influencer has directly tagged back to your brand, and it's an action they've done while posting, that is probably going to be less risky than if someone has tagged your brand and has either posted the image of the celebrity or tagged back to them. I can think of an example recently where we saw something that the PR agency we work with wanted to repost on our brand content, where it was the beauty artist or makeup artist for a celebrity who posted the picture of the celebrity on the beauty artist's own social media page and tagged back to all the product brands that she had used, including our brand. And that was an instance where I didn't see there being direct permission from the celebrity, so I did not feel comfortable with our brand doing that. I thought there was too high of risk. Now, if it was a celebrity who just happens to love your brand or your product so much that you can assume that likely they would not mind you reposting, there might be a less of a risk there. And maybe even opportunity for you to approach that person and say, should we try to make this a little bit more formal? So keep in mind those types of things. It's obviously about trying to manage risk, trying to feel out what you can do in the feed that will attract less attention. No matter what, if it's a celebrity image and there's the opportunity to find a way to buy the license for that content, that's probably the best way to go, no matter what, because you can never be clear from the original post as to who actually took that photograph, and you always have to be concerned about the photographer's rights. The other case that has been very interesting to follow, both in the fashion space but also addressing hashtags, is this Chanel case against WGACA LLC, which is, I think, what goes around comes comes around. And it's a boutique that's known for carrying a lot of high-end luxury. Once upon a time, we would have called it vintage, but I think some of these styles that they carry are not so much vintage as maybe a few years old. But they've carried brands like Chanel, Louis Vuitton, and they promote that fact. Now, there's obviously there's no real law against them actually being able to sell these goods as sort of non-original from the, as sort of second use or first sale doctrine type situation. But I think the issue here was how they were promoting it. And they were using hashtags to promote their services, their retail atmosphere. They were also using some influencers, it seemed to me, based on poking around on their Instagram site, who they were paying to promote WGACA. And I think that, including with discount sale codes. So I think there was a real problem there because what they were doing is they were combining their mark with some of the luxury goods marks into a merged hashtag. And that's what this case was about with Chanel. What they had done is they had used the hashtag WGACA Chanel on their social media posts. And basically, the Chanel just took that and said that creates the impression that there's an actual approved affiliation between WGACA with Chanel. And the concern by Chanel was that they were somehow inspecting these vintage goods and authorizing that they were of a standard appropriate for resale with Chanel's approval. I think because of the deeper facts of the case, this is why so far it appears that the court seems to be backing Chanel's position. It is still an active case. But there are some other cases out there that have been starting to address hashtags. And I just want to point that out, that you really need to look at the post content. And you need to treat it like a fair use situation if you're trying to use any other third-party marks in your hashtags, and run the same trademark infringement or fair use analysis you would for any other type of advertising use that involves a third-party mark. And I'm going to turn this back to Laura. I think we're coming in close to the conclusion here.
Yes, thank you, Jessica. I know the three of us love talking about this, and we could probably talk about it for another hour, but we want to respect everyone's time. So that was the last slide, and we hope you enjoyed it. Please be on the lookout for our survey that we're going to send you guys after the webinar. We're always looking for new topics to discuss. We try to do these sessions routinely a few times a year, so we'd love to hear from you as to other topics that you want to hear about, so please make sure to send that out. I really want to thank Katie and Jessica for doing such a great job as speakers, and I want to thank our summer associate. I hope she's on the line, Howie Edow. She helped put together these slides, and she did a really good job. So thank you, everyone, for joining us, and we hope you enjoyed it. Have a wonderful day. Thanks.